Welcome back to RR Corporates. Now we are discussing an NCLAT judgment. JSW Energy wins NCLAT relief to bid for Raigarh Champa rail project. The NCLAT has overturned the previous NCLT order and cleared the decks for fresh round bidding in the insolvency process of Raigarh Champa Rail Infrastructure Private Limited. So why does this matter? So because this case ties together with the power generation and strategic infrastructure and key legal principles under the Insolvency and Bankruptcy Code. Let's understand what happened and what this means for Indian corporate insolvency landscape. We'll see the background of the case. Raigarh Champa Rail Infrastructure Private Limited or RCRIPL is a logistics arm of the KSK Group. Its core objective, this company core objective was to construct and operate a dedicated railway corridor to transport coal and raw materials to KSK Mahanadi Power Limited. This is a thermal power plant in Chhattisgarh. In January 2021, RCRIPL was admitted into corporate insolvency resolution process under IPC. However, multiple rounds of litigation delayed the resolution process and prevented any definitive outcome for the creditors or potential acquirers. JSW Energy strategy entry, the strategic entry, fast forward to March 2025. JSW Energy successfully acquired KSK Mahanadi Power Limited for a massive 16,084 crore under IBC. With ownership of the power plant secured, JSW Energy naturally aimed to acquire the rail logistic infrastructures supporting the plant, RCRIPL, to consolidate its energy logistics integration. So the JSW Energy successfully acquired KSK Mahanadi Power Limited for a massive 16,084 crore under IBC. So with the ownership of power plant secure, JSW Energy naturally aimed to acquire the rail logistic infrastructure supporting the plant, RCRIPL, to consolidate its energy logistics integration. However, this attempt would face a legal hurdle. NCLT Hyderabad order in April 2025. The Committee of Creditors and Resolution Professional requested the NCLT to allow fresh issuance of Form G, which is a public notice inviting EOI, expression of interest, from prospective resolution applicants. So why Form G matters? Under CIRP regulations, Form G is a formal restart point for inviting new resolutions plans. Without reissuing it, new bidders like JSW Energy couldn't enter the process. However, Hyderabad NCLT rejected this plea and instead ordered a challenge mechanism among the existing resolution applicants, such as the Medha Group, which already had 100% COC approval. So JSW Energy's application to be included in the bidding was also rejected. This was also rejected. Then NCLAT overturns NCLT order. The matter eventually reached to National Company Law Appellate Tribunal. After hearing all the parties, NCLAT set aside the NCLT Hyderabad order, allowed the resolution professional to initiate a fresh bidding round, including JSW Energy. So this is a significant legal development as it touches on fair opportunity, commercial wisdom of the COC, and importance of competition insolvency resolution. So why this ruling matters? For JSW Energy, the company can now control the full energy logistics. So this chain, full energy logistics chain for its Chhattisgarh thermal operations, and it enhances operational efficacy, operational efficiency, the cost control also. For resolution professionals and COC, yes, it reinforces their discretion and commercial wisdom. It encourages rebidding when justified, especially in high value strategic assets. For India's IB's framework, sends a message that objective of value maximization and fairness trumps rigid procedural timelines. It encourages wider participation in distressed asset acquisition. It also encourages those who were previously sidelined to legally assert their rights when public bidding is denied. So under regulation 36A of the CIRP regulations, Form G can be reissued with COC approval to invite new resolution applications, new resolution applicants. So we can invite COC approval. So this 36A of the CIRP regulations, Form G can be reissued with the COC approval to invite new resolution applicants under regulation 36A. The NCLAT decision reaffirms that when the asset is strategic, fresh inherent could improve recovery, and there is no final resolution plan approved under Section 31 of IBC. So the RP and COC should be allowed discretion to widen participation. This ruling uphold the objects of the Section 25 of the IBC to maximize the value of the assets and ensure fair participation. So the conclusion and takeaway is NCLT's decision, this National Company Law Appellate Tribunal's decision, NCLAT's decision is not just a win for JSW Energy, but a major endorsement of market-driven resolution, creditor-centric decision making, and value maximization under IBC. So it ensures that India's insolvency law remains dynamic, fair, and commercially robust, especially in cases involving strategic infrastructure and linked corporate entities. If you found this case updated useful, don't forget to like and subscribe. We have two channels, RR Corporates and RR Legal Talks. Hit the bell icon so that you will not miss any of the latest updates. Please do subscribe RR Corporates and RR Legal Talks. Thank you.